Committee on Workplace Safety and Respect will come to order. We do have a quorum present. I'd like to welcome everyone to the subcommittee. Members, just a little kind of overview of kind of the goals of the subcommittee. Obviously, it's really important at the legislature that we have a safe and respectful work environment for members, for staff, for media, for lobbyists, and of course, always members of the public. So this task force, or excuse me, this subcommittee was put together so that we can have a transparent process and as well as an open process that will allow us to bring in outside experts, legal experts, public testimony, and member input as well. It's important to me that we also have members that are involved in it because they know how the internal operations of the House work, so they will be involved as well. We're inviting multiple stakeholders to be part of this process. We will invite lobbyists, media, members, of course, and members of the public as well. We're going to look at our House policies and procedures, and we're going to try to find what improvements we can make to make the House a safer place for member, staff, and the public to work. So just a little on the direction. I do have some thoughts on it. We'll do some fact-finding today. You'll see that we have our House counsel here, our Human Resources Department, to look at our current policies and to talk a little about ethics. And we also have and the National Conference of State Legislatures here to give a little bit of an overview. And I would just say, as an end result, I don't know at this time what the end result is, but we're going to look at policies, rules, and legislative avenues with the end goal of making the House a safer, more respectful work environment. So with that, I'd like to start by having our staff introduce themselves. Start with Janelle Bolka, Committee Legislative Assistant.
Hi, I'm Janelle. Nice to meet all of you. Thanks for coming. I'm the Committee Legislative Assistant for this subcommittee.
Yep. And then Megan Rice is new to the committee this year.
Thank you all for being here. Megan Rice.
And then is Troy here? Troy Young? Troy Young on House Research. Dave Sullivan on DFL Research. Ben Weeks up at the table on House Research. And Jorge Mendoza, the committee page. Thank you all for being here. Members, if you could just introduce yourselves quickly as well.
Mike Freiberg, Golden Valley.
Jen Schultz, Duluth. Melissa Hortman, Brooklyn Park. Could I ask a question?
Just as soon as we're done with introductions here. Joyce Pepin from Rogers.
Kelly Fenton from Woodbury.
Thank you. Representative Hortman.
Thank you, Madam Chair. Is it your intention to look at just the workspace of the Minnesota House of Representatives, or are we looking more broadly at workspaces in Minnesota?
Thank you, Representative Hortman. Well, we'll obviously get feedback and input from everywhere, but it's my intention since this is a subcommittee of the House, it is primarily to improve the legislative work environment.
Thank you.
Okay, so today we're going to be hearing from our House nonpartisan research and HR staff on the current House policy against discrimination and harassment, and after that we'll have a presentation from NCSL. So with that, if you could, Ben, if you could just introduce yourself for the tape, go ahead.
Madam Chair and members, my name is Ben Weeks. I'm an analyst with the House Research Department, and I also serve as House Counsel with regard to employment matters.
Madam Chair and members, my name is Kelly Knight. I'm the Director of Human Resources for the House.
Madam Chair and members, we were asked today to do an overview of the House's policy against discrimination and harassment, and we'll get into it now. To begin with, the scope of the policy with regard to what's prohibited, there are two main broad categories. Discrimination is the first one, and in general terms, discrimination under the policy means treating someone differently with regard to employment based on that person's protected characteristics. And we'll go through the protected characteristics on the next slide. Also included in prohibited conduct is harassment, and that's unwelcome behavior based on a protected characteristic that does one of three things: interferes with a person's job performance, creates an intimidating, hostile, or offensive work environment, or when the submission to the conduct affects an employment decision with regard to the person. Also, sexual harassment, which is a form of sex and gender discrimination and a form of prohibited harassment under the policy, is defined separately in the policy, and it's defined the same as it is under the Minnesota Human Rights Act. Additionally, a separate category of prohibited behavior is retaliation, and we'll have a slide on that a few slides from now. And finally, intentionally false or malicious complaints under the policy are also specifically prohibited. Moving on to what protected characteristics are protected under the policy. This is coterminous with the Minnesota Human Rights Act, also some of what's under the federal law, Title VII. They include race, color, national origin, sex, which includes pregnancy, marital status, sexual orientation, which includes gender identity, age, disability, status with regard to public assistance, and familial status. So retaliation, as I said, is a separate and additional type of prohibited conduct. And retaliation is defined in the policy as any adverse job-related action for engaging in protected conduct. And protected conduct, of which there are 5 types, are specifically described in the policy. And those are opposing discrimination or harassment in the workplace, bringing a complaint or reporting an incident of harassment or discrimination, participating in an investigation, testifying in a proceeding relating to harassment, discrimination, or retaliation, and finally, associating with a person or group who are disabled or who are of a different race, color, creed, religion, sexual orientation, or national origin.
Question.
Representative Hortman?
Thank you. Could you describe what would constitute an adverse job-related action?
Mr. Weeks?
Chair Peppin, Representative Fortman, it's broadly defined under the policy. I would take it to mean any negative action, and it can include affecting employment conditions. So I think it can be anything ranging from termination to, in theory, moving someone who had a window view away from a window. The policy, in some ways, is broader than the law, and so I think it would behoove the House to take a broad view of what constitutes an adverse employment action under the policy.
Representative Fortman?
Thank you. So if a person were to have alleged deficiencies in their performance that were only brought to light or discussed after a person had engaged in protected conduct, would that be adverse job-related actions?
Mr. Weeks?
Chair Peppin, Representative Fortman, yes, it could. To the degree it affects someone's ability to do their best job. Really, it's about being treated differently than other peers for a bad reason, which means either because you engage in protected conduct or because of your protected class.
Thank you. Mr. Weeks, I have a question as well.
Yes.
On the retaliation, the first one, it says, protected conduct is opposing discrimination and harassment in workplace. Could you talk a little bit about opposing discrimination, what exactly that means?
Chair Peppin, in the policy, it does say, and I'm quoting, opposing discrimination and harassment in the workplace. So that's as much guidance as we get directly in the policy. I think because it's written so broadly that the House would want to interpret it quite broadly. So I think everything from, importantly, bringing forward a complaint, bringing something up with a supervisor or anyone else that the person bringing it up viewed as harassment or discrimination, speaking out publicly against harassment and discrimination in the workplace, it would be a broad set of things. And I think, you know, a good test for it, if you're thinking about whether someone is opposing harassment and discrimination in the workplace, is, you know, just a layperson test. Does it look like they're trying to stop harassment and discrimination in the Minnesota House of Representatives? Do they believe that's what they're doing? Is that the likely effect of what they're doing?
Thank you. And then just a follow-up on that in retaliation, since this is a workplace that we're in, if somebody were accused of some form of sexual harassment, if they were to come back and tell their side of the story, is that protected, or is that considered retaliation if they were to say, well, this, you know, they told you this, but this is what this person did to me, and they hadn't reported it before, but if they're they're explaining themselves or whatnot. Is that protected or is that considered retaliation?
Chair Peppin, context makes a big difference. I think when you're thinking about retaliation, the intent of the person matters. If everyone's in good faith doing their best to try to eliminate harassment and discrimination in the legislature, I wouldn't think anything under that would be retaliation. But if someone's acting specifically to affect someone else's job here at the House, and they're doing it because that person engaged in protected conduct under the policy, that's what retaliation is.
I think that's it for now, if you want to proceed.
Sure. Moving on to the next slide, scope. Scope with regard to people to whom the policy applies, and this, there's a little nuance here, and it gets into one of the challenges for the House policy with regard to people other than members or employees. So there's two clear groups to whom the policy applies, who it protects and who it puts an onus on, and those are members of the House of Representatives, employees of the House, and that's defined broadly in the policy, includes everyone from permanent staff to session-only staff, interns, high school pages, everybody who's here. And I'm also going to read a separate quote from the policy that broadens the scope of to whom the policy applies. And it says, "This policy is designed to eliminate discriminatory and harassing behavior by and against members and employees in encounters during the course of their work with third parties such as senators, other legislative employees, visitors, constituents, press persons, lobbyists, service persons, or state employees employed by other branches of government." So I've added that underlining because there's a couple important things here. So it uses the phrase by and against. So I read that to mean that the policy intends to protect members and employees from harassing, discriminatory, retaliatory behavior of all these third parties listed below. It also intends to protect all of those third parties listed below from harassing, discriminatory, retaliatory behavior from members and staff. For various reasons, this is a challenge on the policy. It's much easier for staff and members of the House to report in the House. It's much easier for House staff and members to investigate reports about or by members and employees. And I'm sure this is something this committee will discuss in more detail later. It's a challenge implementing this aspect of the policy. And finally, where the policy applies physically, it's not super well laid out in the policy itself, but my reading was the policy clearly applies to the Capitol complex, what we all tend to think of as our normal work environment, the Capitol State Office Building, likely a Senate Office Building, and the executive branch buildings around. It also specifically states that the policy covers interaction of members and employees away from the Capitol complex at legislative-sponsored events, professional meetings and seminars, and those activities which involve legislative business. And I'm going to turn it over to Ms. Knight, who's going to talk about the specific responsibilities on individuals and institutions laid out in the policy.
The responsibilities of the Minnesota House are to publish and post our policy, to inform all employees and members about the policy and the procedures, and as well as train not only employees and members and supervisors. And staff come in contact with our policy several different ways. Everyone is given it a copy of the policy the minute they walk in the door, and then staff are required to attend training every 5 years to brush up on the training. Supervisors are also required to go every 5 years, or if they move from a staff role to a supervisory role, they are not allowed to be on our reporting list until they have completed that training. The policy has a policy of compliance of personnel decision makers, and this can involve a caucus leaders, the members of each caucus's personnel committee, supervisors, and department heads. The responsibilities include take appropriate action when the policy is violated, that there is a fair, efficient, and careful handling of all complaints, and that we regularly review the policy and the procedures. The responsibility of supervisors are to promote a workplace free from discrimination and harassment, address discrimination and harassment when observed or reported, respect privacy as much as possible of all involved in a discrimination or harassment concern or complaint, to promptly report observations or complaints of discrimination or harassment to the HR director or the Employment Law Council, and again, to participate in training. The responsibilities of members and staff are again to promptly report concerns or complaints, to participate in training, to cooperate with investigations, and to be sensitive to and eliminate discrimination and harassment in themselves and amongst peers.
Now I'm going to talk about reports, sometimes called complaints of discrimination and harassment. The policy allows reports to be made to a broad list of people here at the House, lists any House supervisor, as well as the Speaker, the Majority Leader, and the Minority Leader. We have taken a broad view of any House supervisor. You've been given a piece of paper that lists all of the current, as of February of this year, supervisors, people to whom staff members or members of the public may make reports. They include both everyone who's considered a supervisor or department head on staff here at the House, as well as the Speaker, Minority, and Majority Leader, and the members of both personnel committees of both caucuses. This is handed out, but it's important to note that this is also on our public-facing House website under House policies. Both our policy and a version of this that is updated as we update it is available, and we do update this with some regularity as people leave the House who are supervisors, or as new supervisors come on and receive supervisor training, people are taken off or added to that list. The policy also describes the form that a report of discrimination or harassment may be submitted. It says it can be in writing, in phone, in person, or by any other means. I think the important takeaway from this section is that there's no such thing as a formal complaint, and there ought not be barriers to bringing a report of harassment or discrimination based on the form a person chooses to use to communicate that to a House supervisor on the list. Indeed, in training, staff are encouraged to bring forward anything that makes them feel uncomfortable or that they think is a problem under the policy. And I think it's important to note for staff and members, when they're thinking about whether to bring something forward, it's not that person's burden to worry about whether it fits the definition of harassment and discrimination in the policy. They should feel comfortable bringing forward anything that they think is a problem, that's affecting their best work, that's affecting a colleague's best work, or something they just see that makes them feel uncomfortable or gives them a feeling that someone else should know about it. We would encourage anyone to bring those things forward. Additionally, the policy specifically states what the law also explicitly allows, which is that anyone also has a right to bring a charge with the Department of Human Rights or the Equal Employment Opportunity Commission, which are two, a state and federal regulatory agency that address complaints of discrimination and harassment under the law. And people always have a right to consult with an attorney of their choice as well. And you can do both things. You have the full range of options. And now I'll turn it back over to Ms. Knight.
The policy also lays out some of the parameters for the investigation. There's a discussion with the person bringing the report or complaint forward. We're as discreet as possible. Information is shared only with those who have a need to know. We are prompt, thorough, and fair. Members and employees are expected to cooperate. The alleged offender is notified, given an opportunity to provide information. The proposed resolution is shared with the person bringing the report and offender while working to protect privacy. Retaliation is also stressed at all phases of this, and that it's strictly prohibited. In addition, leadership also has the option to use an outside investigator or fact finder. As far as resolution and discipline, for employees, the resolution can include a variety of things: an apology, direction to stop the behavior, counseling or training, oral or written warnings, transferred to another position or department, suspension, or termination. For members, disciplinary action involving members of the House will be handled by leadership or pursuant to House rules.
And Chair Peppin and members, that's all we have. I will just point out, this is the policy. It is handed out. We have many copies available. It is also in total on the public-facing House website. You can get there by going to the House's website. Kind of the last center bar is news, policies, and procedures, and House policies is a tab under that. You can get to this there. It's only 12 pages long. They're pretty sparse pages. I would just urge everybody to just read through it, read it, familiarize yourself with it. And thank you, and we're happy to stand for any questions.
Thank you. We do have some member questions. Representative Fenton.
Thank you, Madam Chair. One thing I heard over and over as you were going through this, these are broad terms. So in your opinion, should we make them less broad and more specific?
Mr. Weeks.
Or is it in line with what other corporations or just the laws surrounding this in general?
Chair
Mr. Weeks?
Peppin, Representative Fenton. So the policy states that it is intended to be a reflection of the law, and specifically the most protective law with regard to harassment and discrimination that applies is the Minnesota Human Rights Act. The federal law also applies, but the Minnesota Human Rights Act protects more categories. I think clarity is always good in the policy, but these things are always fact-specific. My concern in the policy of being overly regimented about what is and what isn't is that I think as a workplace, as an institution, we want to eliminate these behaviors. The way we eliminate these behaviors is do everything we can to allow people to feel comfortable bringing forward problems and then address those problems. And I think describing broadly what's problematic conduct is ultimately good. Because if someone, for instance, brings something forward that doesn't rise to the level of unlawful discrimination or harassment, that's also likely a management problem, right? There's something in the department, someone's bullying, being unfair, there's at least a problem there that we're better off if the House knows about it.
Senator Fenton.
Thank you, Madam Chair. Ms. Wright, you talked about your regularly reviewing the policies, and I noticed on the Policy Against Discrimination and Harassment Handbook, it was revised in 2008. So when you're what would constitute a rewriting of these policies as you're changing them, and since you're regularly reviewing them?
Ms. Knight.
Representative Fenton, members, we review the policy to see, where there'll be changes. I'm hopeful that there'll be some changes coming out of this. My goal is always, as Mr. Weeks had indicated, to keep it broad. When we train staff, we've purposely asked that the training be very broad. And again, that they don't determine what is sexual harassment or what is not sexual harassment, what is race discrimination. But I want them to come forward if something gives you pause, if something stops you and makes you say, oh, that was uncomfortable. I want people to come forward. So I'm open to any and all changes in the policy. And I'm hopeful that that's what's going to come out of this, or recommendations. How can we make it better?
And I just
Senator
have,
Fenton?
thank you, Madam Chair, just one last question. You discussed noting that this is a no formal complaint, correct? But do you keep track of these complaints? So are you looking for patterns of behavior, or do you track them year to year and to see, is there an increase, is there a decrease? Can you discuss that?
Ms. Knight?
Representative Fenton and Madam Chair, yes, I do keep track of it. And I also, if someone brings something to me that perhaps they want to handle on their own, maybe it's more of a management issue, and we'll often talk that through. I still will keep notes on that and check back in with the person to make sure, how is it going? How did that work out? And, and that's even beyond the scope of the policy, but we do keep track of it, because there may be one incident and you think that has been resolved, but we do keep track to make sure that, is it reoccurring?
Thank you, Madam Chair. No further questions.
Thank you. Representative Freiberg?
Thank you, Madam Chair. We were, in our packets, there's a list of 50 or some supervisors to whom reports can be made. On the slide that's still up there, it says disciplinary action involving members of the House will be handled by leadership or pursuant to the rules of the House. I guess I'm just wondering, say a report is made, is there a requirement that there then be an investigation? And what happens if there is no investigation?
Mr. Weeks?
Representative Farberg, there is in the policy a requirement that all complaints are promptly and thoroughly investigated. And that's, in my experience, what has been done. When a complaint reaches us, in consultation with leadership, discuss the best way to do it, whether it's an internal investigation, which is usually conducted by Ms. Knight, or if it's something that we feel needs an outside investigator to do it that way. But yes, there is a burden under the policy that every complaint is investigated.
Senator Freiberg?
Is there then a requirement that the results of that investigation be communicated to the person who makes the complaint?
There is,
Mr.
and
Weeks?
I will, I'm sorry, Chair Pevin. So I'll read from the policy on page 10, discussing the resolution of the complaint. Oh, I'm sorry, it's also on page 10, but it's under, as part of the complaint process. First, the person bringing the complaint forward and the alleged offender have to be advised of the complaint and given an opportunity to provide information. And the investigator and supervisor will discuss any proposed resolution that comes out of the investigation with both the person who brought the report forward and with the person who is alleged to have violated the policy. So the idea is, with an overarching goal of discretion and protecting the privacy to the degree it's possible under the law and under the policy of a person who brings a report of harassment and discrimination forward, that they are also involved in the process and are informed of the results and have agency in coming up with what the results of the process are.
Senator Freiberg?
Thank you. Just a separate question related to Representative Fenton's question. This was, according to the front, was initially approved in 2000. This policy was initially approved in 2001, revised in 2008. What process did the approval of this policy go through? Was it approved by the Rules Committee and then it went into effect, or was it approved by the Rules Committee and then sent to the full House for approval? Is it an internal staff policy? I guess I'm just wondering what formal process this took and revisions to it would take.
Ms. Knight?
Representative Pepin and Representative Freiberg, this policy, when we first made the change in 2001, as well as the subsequent revision, would come before the Rules Committee for approval, as does many of our other policies in human resources.
Representative Freiberg?
Thanks. Thank you. Is it, and then it goes into effect once approved by the Rules Committee, or does it need to go to the full House?
Ms. Knight?
Madam Chair, Representative Freiberg, that is, it goes into effect the minute it's approved by the Rules Committee. It has not gone to the full House.
Representative Freiberg?
Thank you, Madam Chair. I guess this question is for you. Is it your intention that this committee revise this policy following our hearings?
Thank you, Representative Freiberg. As I mentioned at the beginning, I mean, the intention of the committee is to fact-find, go over what we currently do, and then, hear from experts, legal experts, and figure out what our policy is, and hopefully we'll work together to come up with some suggestions. So I don't know the outcome. I don't have a preconceived outcome of what we'll need to change. Maybe we'll get recommendations from our internal staff, our internal legal counsel. Maybe we'll get ideas from outside experts. So I'm not sure what it'll look like at the end, but we will have plenty of hearings to discuss what our policies and procedures are and what other states do and what companies do, and take it from there.
Thank you.
Representative Schultz.
Thank you, Madam Chair. So do we have any policy in place if a leader does not report it to HR, if they receive a complaint, and then this person subsequently reports to a second leader? Is there anything in place to hold that first person who didn't report accountable?
Representative Schultz, could you repeat that question? I had a hard time hearing.
So if a member has a complaint, goes to leadership or someone on this list, that person fails to report to HR for an investigation. Subsequently, that person then goes to a second person. Is there any policy to address that the first person that was reported to didn't follow up?
Ms. Knight?
Madam Chair and Representative Schultz, the policy, part of the conflict is with members or with staff. With staff, our supervisors that are on this list, if someone were to report it to them, are required to bring it forward. And I would think disciplinary action could occur if somebody did not bring something forward. However, I do not have the authority to discipline members. So I think Mr. Weeks might be able to
Mr. Weeks?
better answer.
Chair Pepin, Representative Schultz, I think I would just highlight, it's, as Representative Freiberg said, it's still up on the board. So any discipline involving a member of the House will be handled by leadership or pursuant to the rules of the House. And one venue for that is the ethics process. But with violation of the policy, unlike with a staff member for whom we have a broad range of discipline, firing, apologizing, the full range, it's not the same with members of the House. And it requires, for instance, the equivalent of firing, which is expulsion, requires a vote of 2/3 of the House to do.
Representative Schultz?
Thank you, Madam Chair. So we have the Ethics Committee that we would take this complaint to if someone failed to file this report. I have another question. Are we required, if a member comes to us about a situation, are we then required to report to HR or to a supervisor?
Representative Schultz, do you mean a member that is not on the list of
A
mandatory
member
reporters?
that has a complaint, goes to another member, is that member required to report?
Mr. Weeks?
Chair Pepin, Representative Schultz. So, no. The only people under the policy who are required to report a complaint to House HR or the House Employment Law Council are those people specifically listed on the list. In House research and speaking with Ms. Knight, we are keeping kind of a running mental list of some things that we think might improve the policy on the margins. And perhaps a broader category of members. My thoughts on that, in particular, why there might be some people under a policy who are mandatory reporters and some people who aren't, is that I think the ability to go to a peer or a friend who's also a colleague, knowing that there are no strings attached and that person doesn't have any responsibilities, can be an important thing. And staff have it because, supervisor to supervisor or rank and file staff member to rank and file staff member, we can speak to each other and kind of get our thoughts straight and just have an informal conversation. I think it might also be important to have that member to member as well, because you all know what it's like to be you all far better than we.
Representative Schultz.
So do we have a process in place if someone wants to remain confidential or anonymous to solicit anonymous complaints and investigate the person that's being complained about? So do we have a process in place to handle that so someone can remain anonymous, but something can be investigated?
Mr. Weeks.
Chair Pepin, Representative Schultz, so we don't. So the way, and I would argue that the best you can ever promise someone who brings a report forward is that the House will do its best to treat things as privately as possible. And that's what the policy says. It says complaints will be handled as discreetly as possible, given obligations under the policy and under the law. And in practice, what that means is if someone brings a report of harassment or discrimination forward, and imagine it's just between two people, one bad actor and then someone who's discriminated against or being harassed. The person being discriminated against or harassed brings it forward, but wants to be anonymous. The normal course of that investigation would be to go talk to the person who's alleged to do the harassing or discriminating. And you can do that by saying, someone has brought a complaint forward, what do you have to say about it? That can be useful, but there are two problems. One, especially in a small work environment like that, you're not giving that person full anonymity. People know who each other are, know when they interact with one another in the workplace and things like that. So you can't honestly guarantee that person full anonymity. And frankly, it's much more effective in the investigation to directly confront the person accused of harassment discrimination with the behavior that was problematic and say, did you do this? And then you do your best to make a determination if they admit the behavior, and then that's the investigation. Now, that's not to say there aren't processes. And we would try very hard to keep things as anonymous as possible, and outside investigators also have many ways, given context, of keeping things as anonymous as they possibly can. Also, there are services that employers, corporations often do it, can subscribe to that are hotline or online hotline where people can give whatever information they're feeling comfortable giving, including, not including their own name, that kind of thing. And then I guess the fact of the matter is, though, when the House is left to investigate it, we do the best investigation we can. And sometimes if you don't have certain information, you don't get to a good result.
Representative Schultz.
Thank you. Thank you for that explanation. Might be for Ms. Knight. Should we have a website or somewhere to collect anonymous complaints like other industries, in other industries or other private sector organizations have? Should we also have something similar here?
Ms. Knight.
Madam Chair, Representative Schultz, I don't know the answer to that. And while we've kept a list, as Mr. Weeks had indicated, of thoughts out there, we've also tried not to have any preconceived notions about what that end result looks like, and are hopeful that through other experts coming on, the public, members themselves, that if that's the resolution and that's the best answer, then yes, that's what we should do. But if I don't know the answer to it at this point in time, I think we have to wait to let the process play out and see what the result is.
The questions from members? Thank you very much.
Thank you.
Okay, next, we're going to hear from the National Conference of State Legislatures. Mr. John Griffin has graciously flown in. He's been working on this throughout many states, and thank you for coming here. Give you a second. And if you could just introduce yourself for the tape before you begin.
Thank you, Madam Chair and members, for having me here today. My name is John Griffin. I work for the National Conference of State Legislatures. I started at NCSL in 2009, and I currently work in our Center for Legislative Strengthening. I think, this issue is a massive issue when you think of it like that. I can't think of many areas that would weaken a legislature more than having kind of pervasive sexual harassment or sexual harassment in the workplace. So we began updating our resources on this topic in 2017, and we've been continuing to work on this throughout 2018, as you can imagine. In October of 2017, we held a seminar on human resource management in the legislature, and sexual harassment was a high priority throughout that meeting. As a response to this, we sent a survey on sexual harassment policies and training to legislative HR professionals in all 50 states, and we received back responses from 25 state legislatures and an additional legislative chambers, with about roughly 30 sexual harassment policies from the legislatures or the chambers. We use these responses along with consulting experts in the area, such as attorneys, the Society for Human Resource and Management, and the Equal Employment Opportunity Commission. And we had some recommendations about what a good sexual harassment policy should entail. Sexual harassment policies, should initially note, they provide two huge benefits to an organization. First, they show employees that their leadership takes the matter seriously and have put thought into curbing the behavior and crafting a policy to meet their employees' needs. One thing that's been universally true throughout all the policies that we've looked at is that no two are unique. There isn't a uniform policy, there isn't a cookie-cutter way to do this. Each one seems to be uniquely formatted by the legislature in order to best serve their employees and their constituents. Secondly, and most importantly, a good policy should provide a clear path for a person who believes they've suffered harassment to make their claim. It should provide examples of inappropriate conduct. It should include multiple contacts for harassment victims to report a claim. It should provide a clear explanation of the investigation process and should outline potential discipline for the accused. It also should provide a clear statement providing against retaliation. So far this year, we're aware of 11 states that have introduced new policies, chamber rules, or ethics rules to improve their policies. But I expect all, if not mostly all, states to review or change their policies just in light of the increased attention to the topic. Most of the changes have been have been minor, and they clarify procedures already in place. New Mexico, for example, they changed what was a general reporting process and investigation process into one that specifies reporting procedures when the complainant is a member, a staff, or a third party. The third party component is really key to this. A good policy should apply not to just legislators and legislative staff, but it should also apply to third parties who conduct business in the legislature, namely lobbyists, members of the media, and any vendors that are working within the legislature, as well as members of the general public. All of the 2018 policies that we've seen so far have included these provisions, but many states aren't just stopping at including third parties in their policy. They're also introducing legislation on the topic. This year, just in general, we've seen an unprecedented amount of legislation on the topic. Again, just because of the increased attention to it, we're seeing a lot more actions by the legislature to make statutory changes rather than handling it internally. For example, Georgia requires now that all of the lobbyists, when they register, receive and acknowledge the sexual harassment policy. The legislation makes it clear that a violation of the policy is grounds for sanctioning a lobbyist, and they make it clear that the lobbyist has the ability to report violations to the state. Maryland's designated their state ethics commission to receive complaints by or about lobbyists and has designated an independent investigation of lobbyist complaints when necessary. And Maine and Missouri have introduced legislation requiring lobbyists to attend their mandatory training. We're also seeing a lot of legislation in other areas. We're seeing bills that introduce task forces or commissions on sexual harassment, bills that create anonymous tip lines, kind of like was talked about earlier, to report sexual harassment. Bills like here in Minnesota that would require legislators to reimburse the state when public funds were used to settle complaints. New York's actually introduced legislation that would create a crime of official misconduct for sexual harassment for legislators. In addition to the policies, NCSL's survey also covered training practices within the legislature. The legislatures we polled almost universally had training for legislative staff. Slightly fewer offer training for legislative staff and legislators. The trainings differed greatly by state and quality, but most states responded that at minimum, training was annual and mandatory. After consulting with our trainers, experts, and reviewing the surveys, we made some more recommendations, which I think you have in your packets. The most important of all is that much like changing a culture of a legislature, training's that's most effective when leadership is engaged and supportive of the training. It's also important that trainers incorporate legislature-specific examples. As everyone here knows, unlike other businesses, you don't stop being a legislature at 5 p.m. or a legislator at 5 p.m. You're always kind of on the job, so to speak. Because of that unique difference, you're much more exposed to the public in an official capacity at all times. Because of those differences, it's also better to sometimes offer separate trainings to staff and to legislators to make sure that the training's specific to the area. Also, we have many available resources on the area just in general. We're putting together a training program right now that would recommend some of the practices. And we offered a webinar recently that discussed it as well. Now I'd just like to open it up for questions if anyone has anything.
Thank you. Before we get to Representative Freiberg, you talked about 11 states, and then you kind of listed some of the policies. Would we be able to get that information?
Yeah.
So we can see what the other states have done?
Yeah.
Okay, thank you. Representative Freiberg.
Thank you, Madam Chair. We got a one-page handout kind of summarizing NCSL's recommendations on this topic. You talk about sort of what goes into the policy, what should go into the policy, first of all. I'm curious somewhat about the process that should be used to modify the policy. It sounds like, we here on this subcommittee of the Rules Committee would be the one to potentially make any changes to the policy. This subcommittee is sort of a standard partisan majority committee in our legislature here. There are 4 Republicans on it, 3 Democrats. That system works well for many things. What do you think is the best entity to make changes to this sort of policy? I know there have been calls for a task force of outside parties rather than your standard partisan committee considering it. To me, those proposals make a lot of sense. I guess I'm just curious what your thoughts on that are.
Mr. Griffin?
I think it greatly varies by state. Just one, depending on who changes the rules. In some states, the Rules Committee changes the rules or makes the recommendations for the rules. Sometimes the entire legislature has to see it. Some of these HR policies are internal policies that are modified just internally without there being a legislative initiative, I guess to say. As far as, I think the way this committee's handling it, and this is pretty common right now with the task forces and the commissions that we're seeing set up, is just bringing in outside people and making determinations based on what you've heard both from outsiders and from people who work inside the legislature or with other legislatures.
Senator Freiberg.
I guess just to follow up on that, I imagine it's pretty common. However, I guess my question is more, is it effective? We've seen sexual harassment problems not just in our legislature, but obviously in legislatures all over the state. So do you think having this sort of body, consider it as the most effective way of doing it?
Mr. Griffin?
I appreciate that, Representative Freiberg. And I hate to sound like a broken record but it really does. Based on the state, it really does, just based on the legislature and how it's set up. I understand your question about effectiveness. I think you've clearly made the decision that this is the most effective way. This is a very common practice among states that this is an effective way to do this. I don't really feel like I'm in a position to say overall there's a best way to go about this. States are doing it differently. I think all of them have their pluses and minuses.
Representative Freiberg.
Thank you. One other question. The second half of this sheet talks about that there should be an effective, I guess it says an effective sexual harassment training program. It says it should be mandatory. It describes how it should proceed. It doesn't talk much about the substance of what should go in there or what makes it effective. I mean, the one we had last week was fairly widely reported to present a viewpoint that is more sympathetic to the harasser rather than to the people who are harassed. I guess, do you have any thoughts about what would go into a sexual harassment training program to make it effective?
Yeah, that's a great question,
Griffin?
Representative Freiberg. Thank you, Madam Chair. I think, well, one thing we do mention in there that I think is what really makes it effective is if you're having an annual training, you're not just repeating the same things over and over again. People will check out that way. So making sure that it's varied and that you're kind of offering different perspectives in each training to keeping the people attending the training engaged is very important. I mean, there's some parts of training that you just can't get around. You have to make sure that you, cover the standard, the law of it. And then I think just speaking specifically about legislator or legislative staff issues, without, this is not the same work environment as your standard corporation. Legislators and staff have very unique power dynamics, have very unique roles within the legislature. And so just to make sure that whoever you're hiring or whoever is conducting the training makes a special point to really emphasize the uniqueness to working in a legislature is probably the most effective way.
Thank you. I just have a follow-up question on Representative Freiberg's question, and there has been a proposal for a task force in addition to this subcommittee. I'm just wondering if other states have done that, and if so, what is the teeth to actually make it happen? How do you keep it, if the idea is to keep it completely out of the legislature's hands and not have partisan or, self-protecting members dealing with the policy, how do you implement it? If it's an outside task force that says these are the policies, how then are we as legislators held accountable under that kind of a scenario? So I guess kind of two-part, are other states doing this? And if so, how is it implemented?
Thank you, Representative Pepin. In general, states are doing this. There are outside task forces. Everyone I'm aware of that's an outside one still is required to kind of make a report to the legislature at the end, that in a public kind of hearing, either with the Rules Committee or with the Ethics Committee or something, and then those recommendations are made to the legislature. The legislature is not at that point, required to follow any of them, but there is a public kind of facing, these are our recommendations, this is what we think you should do, and then the legislature can either apply to their policies or do otherwise.
So essentially, the legislature itself would have to vote in some fashion on whether or not to implement the policies.
That's my understanding of it among the states that have kind of employed outside investigators, that they will release a public report.
Representative Schultz. Anybody else on the list? I want to make sure we take advantage of Mr. Griffin today, since he did fly in from Denver to come. So I have a number of questions here, I guess. You might have gone through some of them. Could you talk a little bit about some of the complaint methods that other states have seen work? I think you might have mentioned maybe an anonymous phone line. Are there other methods that other states have done?
So Illinois just enacted a legislation that would create for an anonymous phone line. They're the first state I'm aware of to do so. I think there are legitimate concerns about the effectiveness of that, just again, based on the fact that the legislature's dealings with the public are so much greater than the corporate world. So, and the fact that it could be used it's hard to investigate a complaint if it's anonymous. To thoroughly investigate a complaint, you could be, putting a deluge of complaints into an HR office and affecting the overall effectiveness of the investigation process. As far as what other states are doing as far as the investigation process is, again, in their policies, they're just making it very clear, it will be discreetly handled, or it will be as confidential as possible. States, an interview will be done with the accuser, with the accused, with any third parties that witnessed the encounter, and then provides examples of what the resolution would be, so that all parties understand that, these are the possible things that could happen out of this. There could be termination, there could be censure, there could be counseling recommended or something along those lines. So that tends to be the way that they're outlined. One thing in general I didn't mention, but so one thing that comes up a lot is about legislative interns and staff and junior legislative staff. I think a lot of us forget that the legislature is a lot of people's first professional, it was certainly my first professional job and interns. And so they're a lot more vulnerable and less understanding of the process. So what some states have done, I think Montana's done this and California's done this, is making sure that there's very easy to understand like one pager on the policy, so that without getting too tied in, that if somebody feels like they've suffered something, that they're not looking through a 12-page document and trying to figure out how to best report the issue. And so that's been one area where we're seeing some states create something that really helps out and emphasizes the intern issue and junior staff.
So thank you, Mr. Griffin. So would that include, for example, in Minnesota, we have a high school page program, and if a high school page felt as though they were harassed in some way by a legislator or someone else, are other states doing something where they have a way to report that as well?
Yes, Representative Pepin, there are, again, a lot of states just make sure that, like, in their policy, they very clearly state pages are considered employees or under third parties, that as a member of the general public or as someone who conducts business in the legislature, they are covered under the policy. And then again, we'll make it clear who that person reports to.
And then you heard Representative Schultz ask some questions about mandatory reporters. So what do other states do if there's an instance where someone reports an incident to a mandatory reporter and then the mandatory reporter fails to go to the correct place? So in this case, it would be HR. So if the mandatory reporter is told of the complaint and then instead of reporting it to HR doesn't do so, what other states, or how would other states handle that?
It doesn't typically come up in the policy. I would say, legal counsel would probably be best to answer this, but it would usually appear as a general ethics violation. If a member receives a complaint, doesn't do anything, there seem to be a general ethics issue. There also could be considered a form of sexual harassment. If someone's reporting claims and they're not, and no one's taking it to the right person, I mean, that would start to qualify as a hostile work environment. And so you could see that person who failed to report claim to making a hostile work environment. I would say too, from the mandatory reporting, this is a little bit outside of my area of expertise, but it comes up a lot because in the education field, there's a lot of mandatory reporting, and there's been, I know there's vastly different schools of thought on the effectiveness of mandatory reporting. I believe Ms. Knight and Mr. Weeks talked about this a little bit beforehand, but there is a school of thought that says that mandatory reporting can sometimes create a culture where people don't speak out because they just kind of want to share their issue and they're afraid to even share because they know if they say too much, the person will. And there are also people who say mandatory reporting is good because every claim should be reported.
Other questions from members? And how late will you be around today in case we have additional follow-up questions?
I think my flight leaves at 6:30, so
Okay.
got nothing but free time.
Okay, Representative Schultz.
Thank you, Madam Chair. So if we adopt annual training, what is the best format for that training? Is it face-to-face? And I know a lot of organizations use online or web-based training. What are your thoughts on that?
Mr. Griffin?
Thank you, Chair and Representative Schultz. Our trainers would be the best people to answer this. I know NCSL as a training, just general, always believes there should be a face-to-face component. Either if there's recorded video, but there needs to be some sort of face-to-face component. You need to have people who are there and able to offer varied responses or responses that are key to specific questions that people have.
Do you have follow-up, Representative Schultz? Okay, Representative Fenton?
Thank you, Madam Chair. I wanted to ask about, because it's unique when it's legislators and staff and whatnot, about due process. So in the policies, where does due process fit in and how do you balance that?
Mr. Griffin?
Representative Fenton and Madam Chair. So I mean, I think the best way that you can guarantee due process is, again, with the confidentiality and the, most policies do state that it should be, handled discreetly and quickly or something along those lines. I think that's really the best way that you can ensure due process, is that this isn't something that's, released to the public. There isn't an outcome predetermined, and just that, you have the right people in place to make sure that they're investigating these issues fairly. Some states have allowed for, or do allow for, outside bodies to conduct investigation if someone feels that, the person they're accusing is too powerful, or just in some unique role that they don't think they can get a fair shake, that they allow for outside investigators to also conduct the research. But I think it really just comes down to, again, just having a strong policy and having strong cultural commitment that these are handled correctly and that these are handled fairly and justly. So I think that's really more of an overall culture issue than anything else. There's only so much a policy can do in those regards.
Representative Fenton?
No further questions at this time. Thank you, Madam Chair.
Thank you. Okay, any other questions? Okay, thank you, Mr. Griffin. Members, our intention is to have our next committee hearing be next Monday at the same time, and we'll go over looking at the Code of Ethics, and then potentially the LESH proposal, if there's any other proposals that come up. And my intention isn't to necessarily vote on them, but to just get an understanding of what they do and go from there. Anything else? Thank you. Meeting is adjourned.